So here's my question. In the world of employment law, why are we still pretending like arbitration doesn't even exist? Many of you have probably seen the headlines talking about how in Ontario they're looking to completely overhaul our system of civil litigation with the goal, not surprisingly, of reducing the time it takes to get to trial. Will it work? Maybe, maybe not. But here's the real problem. Our civil justice system is a one-size-fits-all system. Whether you're litigating a multi-million or billion-dollar commercial litigation or a simple wrongful dismissal claim, it's the same process. And right now that process is slow, inefficient, expensive, and unpredictable. But here's the interesting thing that we often forget about. You're not stuck with it. You don't have to go to court. You don't have to wait for the governments to fix the court system. You can design your own process, your own system by using arbitration. Even better, build it right into your employment contract, so there's no need to negotiate it later. There will be a requirement that every dispute go before an arbitrator and not before the courts. So why does this make sense? Arbitration is faster. It's more efficient. It's also fully customizable, as I have said, and it's far more predictable. So what do I mean by all that? Well, first of all, in terms of timing, you set the schedule. No more waiting months to get a court date. And when you finally get that court date, you don't have to deal with a judge who shows up late, interruptions, ending early, etc. You decide when the hearing is going to take place. You set the timetable for the whole litigation process. And when you get to court or arbitration, the time is used productively. You start on time, you end on time, and you get things done during the day because the judge is not worried about 17 other matters. Arbitration is also fully confidential, so no airing of sensitive, dirty laundry, no talking about things you don't want the public to know about, and no risk of a damaging precedent. So, for example, you're worried that a court's going to say you've got to give all of your dismissed employees post-termination bonuses. Go to arbitration. It's private. There's no precedent. It's also fully customizable. You get to decide for each case how it's going to work. Is it going to be in person, written, Zoom, hybrid, how the evidence is going to be introduced into the hearing, whether there will be examinations for discovery, whether it's in person or written, whether there's a right of appeal. You get to decide that in each case. For really simple cases, consider final offer selection or baseball arbitration, as we call it. Quick, decisive, and it's done. The other great thing about arbitration, you pick the judge. No more worrying about whether your assigned judge is going to be somebody who understands the nuances of the case you're dealing with. You pick someone with the expertise to handle your case properly and effectively. So bottom line is this. Just because you've always gone to court doesn't mean it's still the best option. If you're counsel, you should be considering arbitration and proposing it where it's appropriate. If you're a party to litigation, ask your lawyer whether they have thought about arbitration. And if you're drafting contracts, build it right into the contract that arbitration is the only way disputes are going to be dealt with. Bottom line is that in 2025, if you are still automatically going to court for every wrongful dismissal case, you're really missing an opportunity. That's all for today.